This brings us to the end of our consideration of Part 7, Search Without Warrants. It also means the beginning of a new part, that is Part 8, entitled Search with Warrants. Search with Warrants. Introduction. Mainly utilized in relation to search of premises or things. For ACJA jurisdiction, see the following: Section 144, subsection 1 and 2, Section 149, subsection 1, 2, 5, and 6, Section 153, subsection 1 and 2. For ACJL jurisdiction, see the following: Section 104, subsection 1, A to C, Section 109, subsection 1 and 2. For CPA jurisdiction, see the following: Section 107, subsection 1, A to C, Section 112, subsection 1 and 2. For CPC's jurisdiction, see the following: Section 74, Section 75, Section 76. The CPC is the only legislation that contains provisions for the procurement of a search warrant to address the offense of false imprisonment or wrongful confinement. Section 77, subsection 1 and 2. A search warrant is basically an order issued by any of the following: a judge, a magistrate, a justice of the peace, a superior police officer. Such an order authorizes the police officer or anyone else named in it to search, seize any property immediately or remotely related to the commission of a crime, and even arrest the occupier of the house or place where such seizures are made. Using the 10 subtopics currently showing on the screen, we will now take a deep dive into search with warrants. 1. Persons authorized by statute to issue a search warrant. 2. Requirements to be met by a person seeking to procure a search warrant. 3. Contents of a search warrant. 4. Time of issue of a search warrant. 5. Period of validity of a search warrant. 6. Validity of a search warrant contingent on its being signed by the issuing authority. 7. A single search warrant can empower more than one person to act. 8. Some notes on the execution of a search warrant. 9. Liability for wrongful procurement of a search warrant. 10. Admissibility of evidence obtained in the course of the unlawful execution of a search warrant. Authority to issue a search warrant in Nigeria as a whole. Our first source is the Police Act. Section 28, subsection 1 and 2 of the Police Act states as follows: the superior police officer may authorize in writing any police officer to enter any house, shop, warehouse, or other premises in search of stolen property, search therein and seize and secure any property he may believe to have been stolen, detain a person on the property as at the time of such seizure, or the person from whom it was taken, if different from the person on whose premises it was, and summon or arrest such a person before a magistrate to account for his possession of such property, unless previously charged with receiving stolen property. But see also section 28, subsection 3, which indicates that such power is not broad, but limited, and can only be exercised by a superior police officer if the premises to be searched is currently in the occupation of a person who has been convicted of receiving stolen property or of harboring thieves or any offense involving fraud or dishonesty and punishable by imprisonment, or the premises to be searched has been in the occupation of a person who within the preceding 12 months has been convicted of receiving stolen property or of harboring thieves or any offense involving fraud or dishonesty and punishable by imprisonment. Also see section 2, which defines a superior police officer to mean any police officer above the rank of a cadre assistant superintendent of police. Authority to issue a search warrant, ACJA jurisdiction. Section 143 lists the issuing authorities as a court, a justice of the peace. Section 146, subsection 1 indicates that the word court in relation to search warrants appears to be the judge himself, the magistrate himself, the justice of the peace himself. Authority to issue a search warrant, ACJL jurisdiction. Section 164, subsection 1 states that the issuing authority must be a magistrate. Section 106, subsection 1 appears to make it clear that this is a personal task and not one he can delegate. Authority to issue a search warrant, CPA jurisdiction. Section 107, subsection 1 states that the issuing authority must be a magistrate. Section 109, subsection 1 states that signing a search warrant is a personal task. It is not a task that a magistrate can delegate. Authority to issue a search warrant, CPC jurisdiction. Section 74 states that the issuing authorities are a court, a justice of the peace. Requirements to be met by persons seeking a search warrant. ACJA jurisdiction. Issued based on information on oath and information in writing. Section 144, subsection 1. ACJL jurisdiction. Issued based on information on oath and information in writing. Section 104, subsection 1. CPA jurisdiction. Issued based on information on oath and information in writing. Section 107, subsection 1. CPC jurisdiction. The legislation is silent, so by implication, this is not a requirement. Contents of a search warrant. Who it is issued to. Issuing authority. Place to be executed. What should be searched for? Time to be executed. Issue date. Signature. Issue place. Time of issue of a search warrant on any day, including weekends and public holidays. ACJA, Section 148. ACJL, Section 108, Subsection 1, CPA, Section 111, Subsection 1, CPC, silence on this. Period of validity of a search warrant. In nearly all of Nigeria, the rule is that it remains valid and in force until executed or cancelled. Please see Section 146, Subsection 2, ACJA, Section 106, Subsection 2, ACJL, Section 109, Subsection 2, CPA. Also note that the CPC is silent on this issue. Validity contingent on its being signed by the issuing authority. Section 146 ACJA, Section 106 ACJL, Section 109, Subsection 1, CPA. CPC is silent on this. A single search warrant can empower more than one person to act. Section 147 ACJA, Section 107 ACJL, Section 110 CPA. CPC is silent on this. Execution of a search warrant. The precondition to the execution of a search warrant is its presentation to the person who resides in or manages the building, place, or thing to be searched. Section 149, Subsection 1, ACJA. Section 109, Subsection 1, ACJL. Section 112, Subsection 1, CPA. Section 34, Subsection 2, CPC. Section 78, CPC. Inventory of property of suspects. The person authorized to execute the search warrant is duty-bound to generate an inventory of seizures from the person of the suspect. The inventory of seizures should be signed or sealed by the following: the person to whom the search warrant is addressed, the person executing the search warrant, the witnesses. A witnessed copy of the inventory of seizures must be given to the person searched. Section 149, Subsection 5. This is an innovation of the ACJA. In ACJL jurisdiction, the legislation is totally silent on the duty to inventorize seizures taken from the person of the suspect. In CPA jurisdiction, just like the ACJL jurisdiction, the legislation is totally silent on the duty to inventorize seizures taken from the person of the suspect. In CPC jurisdiction, just like the ACJ jurisdiction, the legislation is totally silent on the duty to inventorize seizures taken from the suspects. Presence of witnesses during the execution of a search warrant. In ACJA jurisdiction, as a general rule, witnesses should observe a search conducted courtesy of a search warrant. As a general rule, at least 2 witnesses should observe the search. As a general rule, The person to whom the search warrant is addressed can provide his own witnesses. The only exception to the general rule is that if the facts of the case so dictate, then the court or justice of the peace may direct the search to be conducted in the absence of witnesses. Section 149, subsection 4. In ACJL jurisdiction, legislation is silent on this. In CPA jurisdiction, legislation is silent on this. In CPC jurisdiction, as a general rule, witnesses should observe a search conducted courtesy of a search warrant. The only exception to the general rule is that if the facts of the case so dictate, then the court or justice of the peace may direct the search to be conducted in the absence of witnesses. Section 78, CPC. Signing and or sealing of inventory of seizures. In ACJA jurisdiction, this is the practice. Section 149, subsection 5. In ACJL jurisdiction, there is no provision for this. In CPA jurisdiction, there is no provision for this. In CPC jurisdiction, this is the practice. Section 78, Section 81, subsection 2. Accommodation for the practice of screening women from men or strangers. In ACJA jurisdiction, yes. Section 149, subsection 6. In ACJL jurisdiction, the law is silent on this. In CPA jurisdiction, the law is silent on this. In CPC jurisdiction, yes. Section 79, CPC. Right to personally observe or observe indirectly through representatives the execution of a search warrant. In ACJA jurisdiction, yes. Section 150. In ACJL jurisdiction, no. In CPA jurisdiction, no. In CPC jurisdiction, yes. Section 80, CPC. Right to a witnessed copy of the inventory of seizures. In ACJA jurisdiction, yes. Section 150. In ACJL jurisdiction, no. In CPA jurisdiction, no. In CPC jurisdiction, yes. Section 80, CPC. Seizure of items responsive to the search warrant. In ACJA jurisdiction, yes. Section 144, subsection 2A. In ACJL jurisdiction, yes. Section 104, subsection 1I. In CPA jurisdiction, yes. Section 107, subsection 1C and I. In CPC jurisdiction, yes. Section 74, CPC. Section 76, subsection 1A. Duty to allow police officer access to locked premises. In ACJA jurisdiction, yes. Section 149, subsection 1. In ACJL jurisdiction, yes. Section 109, subsection 1. In CPA jurisdiction, yes. Section 112, subsection 1. In CPC jurisdiction, yes. Section 34, subsection 2. Police officer empowered to use reasonable force to access place or premises or thing if residents or manager uncooperative. In ACJA jurisdiction, yes, section 149, subsection 2. In ACJL jurisdiction, yes, section 109, subsection 2. In CPA jurisdiction, section 112, subsection 2 and section 7, subsection 2. In CPC jurisdiction, only section 77, subsection 2, which deals with search for person wrongfully confined, specifically mention the use of necessary or reasonable force. Also, section 34, subsection 3, but notes as per section 34, subsection 4, that the provisions of this section are subject to the provisions of section 79. Police officer empowered to break out of a house or place if denied free exit. In ACJA jurisdiction, yes, section 13. In ACJL jurisdiction, yes, section 8. In CPA jurisdiction, yes, section 8. In CPC jurisdiction, yes, section 36. Duty to authenticate outside of jurisdiction and proceed under the direction of a court that has jurisdiction. ACJA, section 151. ACJL, silence. CPA, silence. CPC, section 83. Time of execution of search warrants. Section 148, ACJA, anytime, any day. Section 108, subsection 2, ACJL, between 5 a.m. and 8 p.m. Section 111, CPA, between 5 a.m. and 8 p.m. CPC appears to be silent on this. Liability for wrongful procurement of a search warrant. If a complainant acted in good faith, then the search warrant may be said to have been procured correctly. If a complainant acted in bad faith or malice, then the search warrant may be said to have been wrongfully procured. This is because Section 37, 1999 Constitution guarantees privacy of Nigeria's citizens and residents, while Section 45, subsection 1, 1999 Constitution provides the exceptions to the general rule on the guarantee of such privacy. An illegal procurement or execution of a search warrant does not fall within the exceptions, and as a consequence, the complainant who made the bad faith report will be liable to the alleged offender in tort. The authority for this is Adefunmilayo versus Odutan, a 1958 case. Such a complainant may incur liability for damages from the malicious procurement of a search warrant if the alleged offender suffered illegal arrest and detention, then liability for false imprisonment would follow. According to Garba versus Maigoro, a 1992 case, the test is objective. What did the defendant know at the time of the complaint? Did the facts as known to the defendant at that time disclose reasonable and probable cause to conduct a search on the plaintiff's property or to arrest? Yet, another consideration in establishing the guilt or others of the defendant is the answer to the question, did the defendant set the law in motion against the plaintiff or not? If yes, then he is guilty. Balogun versus Amubikaho, a 1989 case. In Adefumilayo versus Odutan, a 1958 case, the defendants made out a case of theft against the plaintiff. In the course of their pre-trial investigations, the plaintiff was arrested and detained briefly. Since the investigations failed to conclude that the plaintiff committed the theft directly or indirectly, the plaintiff then proceeded against the defendant in an action claiming damages for false imprisonment and succeeded, since the court held that even the police investigations could not substantiate the allegations. While in Balogun versus Amubikaho, a 1983 case, which was actually a land dispute, the appellant made a false accusation that the respondent sent a woman to eliminate him. In the course of their pre-trial investigations, the woman was arrested. The arrested woman claimed in a statement to the police that the respondent indeed sent her after the appellant. A court trial revealed, though, that her accusation was false and that the appellant induced her to make the false accusation. This led to the court discharging the respondent. The respondent immediately instituted an action against the appellant for malicious prosecution. The action was successful and he was awarded damages. The Supreme Court held that even though the police arrested and prosecuted the alleged offender, the person responsible for the action of the police was the fabricator of the false criminal complaint, and so he alone should bear the consequences of his illegality. Admissibility of evidence obtained in the course of the unlawful execution of a search warrant is illegally obtained evidence, that is, evidence obtained in the course of an illegal execution of a search warrant, admissible in evidence? Well, there are two positions of the law, the old position or old law, the new position or current law. Old position of the law. Any and all evidence is admissible provided that it is relevant, with the exception of evidence obtained as a result of an involuntary confession. Kuruma versus R, a 1955 case, and Musa Saudao and another versus State, a 1968 case. New position of the law. According to Evidence Act 2011, the current position is that any and all evidence is admissible, including evidence obtained improperly, evidence obtained in contravention of a law, unless the court comes to the conclusion that reasons for excluding such evidence are greater and more significant significant than the reason for admitting such evidence. Section 14 and 15, Evidence Act 2011, then goes ahead to list matters or issues that the court should or should not be excluded.